If someone asked you right now, how does the Australian legal system actually work? Could you explain it? Most people can't. And honestly, that's not their fault. The system isn't taught properly in schools. It's wrapped in Latin phrases and old traditions. And let's be honest, most legal explanations are written by lawyers, for lawyers. Not this one. In the next 12 minutes, I'm going to walk you through the entire structure of the Australian legal system, how laws are made, who interprets them, and why it matters to you. In plain English, whether you're a first-year law student trying to get your head around the basics, a business owner who wants to understand the rules you're playing by, or just someone who's curious, this is for you. Let's get into it. Everything starts with one document, the Australian Constitution. It came into effect on the 1st of January, 1901, when the 6 colonies federated to become the Commonwealth of Australia. Think of the Constitution as the operating manual for how Australia is governed. It does 3 critical things. 1. It creates the 3 branches of government: the Parliament, the Executive, and the Judiciary. We'll come back to these in a moment. 2. It divides power between the Commonwealth, the federal government, and the states and territories. This is important because not every law comes from the same place. 3. It sets the limits of government power. The government can't just do whatever it wants. The Constitution defines what the Commonwealth Parliament is actually allowed to legislate on. Now here's something most people don't realise. The Australian Constitution can only be changed by a referendum, a national vote, and it's deliberately hard to change. You need a double majority, a majority of voters nationally, and a majority of voters in a majority of states. That's at least 4 out of 6 states. Since 1901, there have been 44 referendums. Only 8 have succeeded. That tells you how rigid this document is. And that's by design. The Constitution creates 3 branches of government, and each one has a different job. This is called the separation of powers, and it's one of the most important principles in our legal system. The Parliament. This is the legislature. Its job is to make the law. At the federal level, that's the House of Representatives and the Senate. Each state has its own parliament too. When you hear that a new law has been passed, it means it went through Parliament. The Executive. This is the government of the day. The Prime Minister, the Cabinet, the Ministers, and the departments and agencies that sit underneath them. Their job is to administer and enforce the law. They put the laws into practice. The Judiciary. These are the courts and the judges. Their job is to interpret the law and resolve disputes. When there's an argument about what a law actually means, or whether someone has broken a law, the courts decide, because no single branch should have all the power. The people who make the laws shouldn't be the same people who judge whether you've broken them. That's a fundamental safeguard against tyranny. It's not perfect. In Australia, the executive is drawn from the Parliament, so there's some overlap. But the judiciary is strictly independent. Judges cannot be politicians, and politicians cannot be judges. That independence is what protects your rights. There are 2 main sources of law in Australia. Understanding this is fundamental. The first is legislation, also called statute law. These are laws made by Parliament. A proposed law starts as a bill. It gets introduced into Parliament, debated, potentially amended, and if both houses agree, it receives royal assent from the Governor-General, or the Governor at state level, and becomes an Act of Parliament. Every time a politician says, "We're going to pass a law to fix this," they're talking about legislation. Examples you've probably heard of: the Fair Work Act, which governs employment; the Corporations Act, which governs companies; the Criminal Code. These are all pieces of legislation. The second source is common law, sometimes called case law or judge-made law. This is law that develops through court decisions. When a judge decides a case and gives reasons for that decision, those reasons can become binding on future cases. This is called precedent. Here's a simple example. The concept of negligence, the idea that you owe a duty of care to people who might foreseeably be affected by your actions, that wasn't created by Parliament. It was developed through court decisions, most famously a case called Donoghue versus Stevenson in 1932, involving a decomposed snail in a bottle of ginger beer. I'm not making that up. It's one of the most important cases in legal history. These two sources work together. Sometimes Parliament passes legislation that overrides or codifies common law. Sometimes courts interpret legislation in ways Parliament didn't anticipate. It's a constant dialogue between the two. Now let's talk about the courts, because this is where most people get confused. Australia has a dual court system, federal courts and state courts, and they're arranged in a hierarchy. The hierarchy matters for two reasons. It determines which court hears which type of case, and it determines whose decisions are binding on whom. Let me walk you from the bottom to the top. At the base, you've got the local court, or magistrates' court, depending on the state. This is where most Australians will encounter the legal system. Minor criminal matters, traffic offences, small civil disputes, apprehended violence orders. A magistrate presides, not a judge. There's no jury. It's relatively informal, and cases move quickly. One level up is the district court, called the County Court in Victoria. This handles more serious criminal matters. Think armed robbery, serious drug offences, sexual assault, and larger civil claims. Cases here are heard by a judge, and for serious criminal charges, there's often a jury. Each state and territory has a Supreme Court. This is the highest court in the state system. It handles the most serious criminal matters, including murder, and complex civil disputes. It also has an appellate division, a court of appeal, that hears appeals from the lower courts. Then you've got the federal courts. The Federal Circuit and Family Court handles family law and some migration matters. The Federal Court of Australia handles things like intellectual property, corporations law, tax disputes, and employment law matters under the Fair Work Act. And right at the top, the High Court of Australia. This is the final court of appeal in the country. Its decisions are binding on every other court in Australia. It also has a special role as the guardian of the Constitution. It decides constitutional questions, like whether a particular law is valid. The High Court has 7 justices. Getting a case to the High Court requires special leave. They choose which cases to hear, and they only take cases that involve important questions of law. The key principle here is this: a lower court must follow the decisions of a higher court in the same hierarchy. A local court magistrate in Sydney must follow a decision of the NSW Supreme Court, and every court in Australia must follow the High Court. That's how consistency in the law is maintained. One of the most common confusions is which level of government is responsible for which laws. The Constitution gives the Commonwealth Parliament specific powers to legislate. These are listed in Section 51. They include things like trade and commerce, taxation, defence, immigration, marriage, banking, and corporations. Anything not in that list is generally left to the states. So, criminal law, property law, health, education, road rules, most contract disputes, these are primarily state matters. This is why criminal law in NSW can be different from criminal law in Queensland. Each state has its own parliament and its own legislation. It's also why you might hear about jurisdictional issues. Sometimes it's not immediately obvious whether a matter falls under federal or state law. And here's the kicker. Section 109 of the Constitution says that when a state law conflicts with a valid Commonwealth law, the Commonwealth law prevails. The state law doesn't disappear. It just becomes inoperative to the extent of the inconsistency. Lawyers call this the inconsistency provision, and it comes up more often than you'd think. Now you might be thinking, this is interesting, but why does it matter to me? Because the law touches everything. Your employment contract is governed by legislation. Your lease agreement is shaped by common law and statute. If you start a business, you're regulated by the Corporations Act. If you get injured at work, your rights depend on which state you're in and which legislation applies. Understanding the structure means you know where to look, who to ask, and what questions to raise. You don't need to be a lawyer, but you do need to understand how the system is built, because it's built around you. That's the Australian legal system, the foundation, the structure, and the logic behind it. Plainly explained. If this helped you, hit subscribe. We're going to be covering specific areas of law in upcoming videos. Contract law, employment law, criminal law basics, your rights, when dealing with police, and a whole lot more. Drop a comment and tell me, what area of law do you want explained next? I'll see you in the next one.